federal power, use of force, and the Fourth Amendment. Recent shootings involving federal immigration officers have renewed debate about enforcement, use of force, and the rights of citizens. At the center of that debate is the Fourth Amendment. The Fourth Amendment protects people from unreasonable searches and seizures by the government. In practical terms, it means the government cannot detain, search, or use force against a person without legal justification. And any force used must be reasonable in scope and proportionate to the threat perceived at the moment. That protection applies to citizens, regardless of which agency is involved. Federal authority does not suspend constitutional rights. Federal immigration officers are authorized to enforce immigration law and, like all law enforcement, may use force when they reasonably perceive an imminent threat of serious harm. That authority exists because enforcement sometimes occurs in uncertain, fast-moving environments where hesitation can be dangerous. But authority is not permission without limits. Use of force is not judged solely by the presence of danger, but by how force is applied, when it is escalated, and whether lesser options were reasonably available. These decisions are made under stress, with incomplete information, and often in seconds, but they are still subject to review, scrutiny, and accountability after the fact. Officers carry both legal authority and moral burden. Every use of force decision leaves consequences not only for the subject involved, but for public trust, institutional legitimacy, and the officers themselves. The tension between federal enforcement power and individual liberty is real. It is not resolved by outrage or dismissal of risk. It is resolved through clear standards, transparent investigation, and a disciplined examination of facts, separate from emotion or narrative. This is not a legal position. It is an examination of power, restraint, and consequence. This is the examiner.